I have completed the state, and today I'll be discussing with you Article 13. Now, Article 13, is in Part 3rd of the Constitution, that is fundamental rights. Now, one of the thing which is important for fundamental rights in India is that these fundamental rights are not merely, we can say, the moral precepts or something like teachings to the common man, or these are certain guidelines, but they are also cannot be said to be the instructions or dictums like what we find in the Declaration of the Rights of Man in the French Revolution in France, or what is there in the UDHR, that is Universal Declaration of Human Rights, meaning thereby that these fundamental rights are not only the guidelines or instructions, but they have teeth also. When I'm talking about that they have teeth, it means that there are the provisions in the Constitution itself which makes them applicable, which makes them implementable, which provides that the fundamental rights are not only declarations, but they can be exercised, implied by the persons, by the citizens, as the case may be. So it is made clear by the provisions in the Constitution itself. If we see Article 13 as well as Article 32 of the Constitution, so these two articles basically gives the fundamental rights teeth, along with Article 226 also, where the jurisdiction of the high courts are there, that for the violation of the fundamental rights, along with the other rights, the person can move to the High Court, but directly under Article 32, one can move to the Court of Law. So fundamental rights in India are not only declarations, are not only guidelines or dictum or instruction, what we say, but they have a certain teeth, they have the implementation properly, and that we find under Article 13 of the Constitution of India. So Article 13 of the Constitution, that has been included in the Constitution to give the paramountcy to the Constitution with respect to the fundamental rights. That makes the status of the fundamental rights very important. Or what we see that Article 13, it expressly plays down the what we should say, for otherwise would have been implied in terms. So that is the supremacy of the fundamental rights, and supremacy with any other law. If there is any inconsistency between two laws, if there is any conflict between two laws, or if there is something which is contravening the fundamental rights, then the fundamental rights shall be supreme, and this shows under Article 13 of the Constitution, because Article 13 provides for the judicial review. It provides for judicial review. How? Because the courts can pronounce decisions regarding the constitutionality of any legislation. And judicial review that imposes restraints also over the legislative and executive functions of the state, because we see that Article 12, while we were discussing Article 12 of the Constitution, then we have discussed as to how the Supreme Court has expanded other authorities, other bodies within the meaning of Article 12, that is state. So we see that it is not only the legislature which can enact a law, but there are other authorities also which can frame rules, regulations, etc. And these are also coming within the category of law. We'll be discussing this later on. So when we talk about the judicial review of legislative as well as executive action, so executive action here means that whatever is executive is doing as a state under Article 12, and its rules and regulations as law under Article 13, that all are open for judicial review. And that's why you see it was in 2012, the Supreme Court in the famous case of Ramlila Maidan case, Ramlila Maidan incident case, that the Supreme Court has observed regarding Article 13, that Article 13 is the repository. A repository of what? Repository of various protections. And these protections are given to the citizens and otherwise. So this is for what? This is against the violation of their fundamental rights. So Article 13 has been given a very important place in the part 3rd of the Constitution for the purpose of enjoyment and exercise of the fundamental rights. And when we see the position as to what is written in Article 13 of the Constitution, then we'll find that Article 13 deals with basically pre-existing laws, or we know that as the pre-constitutional laws. When we talk of the pre-constitutional laws, it means that the laws which were in existence prior to the enforcement of the Constitution. So Article 13 firstly deals with the pre-existing or pre-constitutional laws, and those laws which are inconsistent with the fundamental rights. Not all the laws, but only those pre-constitutional laws which are inconsistent with the fundamental rights. Then secondly, it deals with the post-constitutional laws or the future laws. Future laws means that when the Constitution has been enforced, then after that the competent legislature, whether it is the parliament or the state assemblies or state legislatures, or at the same time the executive like delegated legislation also. So post-constitutional laws means that those laws which are to be enacted in future after the enforcement of the Constitution. So secondly, this Article 13 deals with the post-constitutional laws or the laws enacted after the Constitution has been enforced and which are in contravention of the fundamental rights. Now see the language of Article 13 clause 1 and clause 2. In clause 1, it relates with the pre-existing laws or pre-constitutional laws, and that speaks of the inconsistency. And Article 13 clause 2 speaks of the post-constitutional laws or future laws, and it speaks of the laws in contravention of fundamental rights. Now when we'll be discussing in detail, then I tell you the meaning of these two different words, that is inconsistency and contravention. Then Article 13 clause 3 defines the law and law in force. There are two things in Article 13. 13 is divided further in A and B, and one speaks about the law includes as to what shall be included in the term law, and second, that is known as the explanation of that law in force, because these are the words which have been used in Article 13 of the Constitution. And finally, fourthly, this Article 13 that speaks about the question whether amendment is a law or not. So we all know that when the Constitution was enforced in 1950, there were only 3 clauses in Article 13. And it was only after 24th Amendment to the Constitution, that was in 1971, that the 4th subclause was also added to Article 13. Now, Article 13 clause 4, that speaks about the questionability of the amendment, that amendment is a law or not. So before moving further, we must know as to what was the debates which were there in the Constituent Assembly regarding inclusion of Article 13 of the Constitution. So we see that K.M. Munshi's draft bill, then Dr. Ambedkar's memorandum, those were basically there along with the constitutional advisor report on this particular provision as to what shall be there in the term law under Article 8. Article 8 was of the draft constitution, and it was renumbered as 13 when the constitution was finally drafted. So draft article is 8 and present constitution it is Article 13. So there were debates on these matters only, and Naziruddin, one of the member, he also spoke regarding custom and usages, which you see is there in Article 13, Clause 3, and that is having the force of law. So all these terms, these were debated there in the Constituent Assembly, but not at great length. So finally, what we are having, that is finally adopted by the Constituent Assembly, and it was renumbered as Article 13. So Article 13 in its first two clauses made it very clear the impact on the fundamental rights of pre-constitutional and post-constitutional laws. This must be very, very clear to all of you. And the important question is when any law which is enacted by the parliament or legislature, meaning the way that is the competent legislature, and that is in contravention of the fundamental rights under the constitution, which we know is the supreme law of the land, then it should automatically become void. So can we say that it is automatically void? Or what stops that to become a void? Because Article 13 confers the power of judicial review, and only the court can declare a law void. It is not to be automatically void, but the court has to declare the law void. So until and unless the case is brought before the court of law, that law will continue to be a constitutional law. So the provisions are there regarding pre-constitutional law and post-constitutional law, and these are to be declared by the court as void. They are not to be automatically void. For example, you see that very recently the Supreme Court has, declared some of the existing laws as unconstitutional or violative of the fundamental rights. For example, you take the example of IPC, okay, Indian Penal Code. Section 377 decriminalized on what fundamental grounds? Fundamental rights. Article 14, Article 21, along with others. Similarly, if you see the case, this is in Tej Singh Johar case, then Joseph Shrine case, you see the constitutional validity was challenged. Again, that was declared unconstitutional for certain matters. Okay, so the law was in existence since 1860. Indian Penal Code was in existence from 1860, but it was declared unconstitutional only when it has been brought before the Supreme Court. Okay, so Supreme Court said that this is violative of Part 3rd, that is fundamental rights. So it has to be brought before the Supreme Court for the declaration that the law is in contravention, law is inconsistent with the fundamental rights or not. So my point here is that the Supreme Court has to declare a law as inconsistent or in contravention of fundamental rights only when there is a case before the court of law. It is not to be automatically declared as void. So any law which is enacted by the competent legislature, whether it be parliament or the state legislatures or the executive rules and regulations, whatever are there, they will continue to be constitutional until and unless they are challenged in the court of law. And if it is challenged in the court of law, then the court will decide that a particular law is constitutional or unconstitutional or violative of Part 3rd of the Constitution or not. So this is how my point is that it is not to be automatically declared void, but it has to be declared only when there is a challenge before the court of law. So we see that in A.K. Gopalan case, it was of 1950, A.K. Gopalan versus a state of Madras case, and their Chief Justice Kania, when he said that perhaps it is done by the framers of the constitution out of abundant caution, that it seems that all the functions of the state, these functions have been divided. The judiciary has its own function of interpretation of the laws. The executive has its function of the executing or implementation of the laws. The legislature has its function of legislating or enacting the laws. But at the same time, this particular provision, that is Article 13, which confers the power on the judiciary for reviewing the laws, that has been put in the constitution as an abundant caution, because the court said that we can see it, or we can say on the basis of our experience that this was not entirely misplaced, this condition, that it is not misplaced, because you see that various laws are there which have been declared by the Supreme Court as unconstitutional. And if this power would not be there, if this provision would not be there in the Constitution, then what would be the value and importance of the fundamental rights? If we say that part third confers upon us the fundamental rights, but the term law and state would not be there in the Constitution, then how the Supreme Court could have, interpreted this term law under its power of judicial review to make it constitutional, to declare it constitutional or unconstitutional. So this was the judgment of the Supreme Court in A.K. Gopalan versus State of Madras case. And the Supreme Court has very clearly said that this is not out of, we can say, just as a matter of fact, but it is taken there as an abundant caution. And India is a country where we see that the people, they are not, or they had not been used for the assertion and enjoyment of their rights. The provisions in part third of the Constitution, if there would not be like Article 13 and 32 of the Constitution, then these fundamental rights would have been only and only directory in nature. These would, as I told you earlier, that these fundamental rights are having the teeth because of these two articles 13 and 32. If this would not be there, then it would again be similar as that of the Universal Declaration of Human Rights or as the rights of man. So these are very important provisions in the Constitution regarding the enjoyment of the fundamental rights. Now, the view that Article 13 was inserted as an abundant caution, then we have the reasons also for it, because we see the expansion of Article 12, that is state in the Constitution, and where the state we find is not only includes the legislative wing of the government, but its executive wing also. And executive can take many actions, different type of the actions which may violate the fundamental rights. And those actions of the executive, though it may not be specifically authorized in the legal terms, we can say. And you see, there was one more case decided by the Supreme Court, that was Balaji versus State of Mysore. In Balaji versus State of Mysore, 1963, this was said by the Supreme Court that the expansion of Article 12, which was taken by the interpretation of the Supreme Court, and that is very important for understanding as to how and why we have to give the importance to the fundamental right. So for the discussion purpose of Article 13, we can go for the definition of Article 13 as to what means by law, what shall be included in the term law. Then whether this Article 13 in terms of the fundamental rights, it is having the prospective application or it would have the retrospective application. Prospective means that only after the Constitution has been enforced. Retrospective means before the Constitution has been enforced, before the date of the Constitution when it came into enforcement. Then the doctrine of Eclipse is also very important for understanding this Article 13. Doctrine of severability is there, which is also, devised by the Supreme Court along with doctrine of Eclipse. Then a waiver of fundamental rights. This is also very important, whether this is to be there or not. Now come directly to Article 13 of the Constitution. Okay. So if you are having the barracks with you, then you will find that the caption of Article 13, which is there in the Constitution, that speaks of laws inconsistent with or in derogation of the fundamental rights. There are two terms used in the caption of Article 13. Laws inconsistent with or in derogation of fundamental rights. So the very caption speaks about inconsistent with. That means something which is already in existence, and now after making constitution that becomes inconsistent. Okay. The inconsistencies here simply means that there are two laws. One is a law which is having made earlier, and the other law is made afterwards. So there are two laws. Now, when we are talking of the afterward laws, then we are speaking of the Constitution of India, that is of 1950. So inconsistency would be there only when there are two laws. One law is already in existence, other law has made afterwards, that is the constitution, and inconsistency would be between the provisions of the existing law and the Constitution of India. So Article 13 in its first clause speaks of the inconsistency. The second clause speaks of in derogation or in contravention of. That simply means that the constitution was already in force, but the competent bodies, whether it is the parliament or the state legislatures or the other authorities, they have enacted afterwards, and they enacted in derogation or in contravention. They are not said to be inconsistent because they don't exist earlier. So the two terms which have been used here in the Constitution, Article 1 and 2, and the caption of Article 13, inconsistent with or in derogation of fundamental rights, simply shows the pre-exist constitutional law and post-constitutional law. So post-constitutional law should not be in derogation or contravention, while pre-constitutional law which exists, that should not be inconsistent. So in both the cases, if we see, then we find that all the laws in force. So the term laws in force is again very important, because you'll see another term used for the force of law. So Article 13 clause 1, that says that all laws in force in the territory of India, that is defined in the Constitution itself, immediately before the commencement of the Constitution. Immediately before the commencement of the Constitution, if they are inconsistent with the provisions of Part 3rd, only Part 3rd, it is not the entire Constitution, only Part 3rd, to the extent of such inconsistency be void. Okay. The term used here is that inconsistent law shall be void. As I told you that it could not be automatically void. It could not be automatically void, but it has to be declared void. And for declaring the void particular law, these laws which are in existence has to be seen with reference to only and only fundamental rights. Because at the time of debate, it was also the matter that why only this chapter is being used, this chapter that is Part 3rd, it has to be used for the entire Constitution in matters of the existing law, but that was not accepted. And we find this, that this is confined only and only to Part 3rd of the Constitution. So clause 1 is relating to the inconsistent laws which are in existence shall be void to the extent of inconsistency. When we are talking of the extent of, then it gives the provision for the severability. Okay. When I am saying that any law which is in existence that is inconsistent with the Part 3rd of the Constitution, so to the extent of inconsistency shall be declared void. So when I am talking of the to the extent, then it simply means that the provisions which are not inconsistent, that may continue. And if that may continue, then how to go about? To go about by applying the doctrine of severability, to sever that part which is inconsistent with that part which is consistent. Okay. So what Article 13 clause 1 speaks about? Only to declare that part as void which is inconsistent with. So this, to the extent what in clause 1 and 2 speaks for the doctrine of severability. So doctrine of severability shall be applicable to both the clauses, clause 1 as well as clause 2. Now, clause 2 of Article 13, that speaks of the state shall not make. Okay. Now, when I'm talking here the state, then you recall what I discussed with you under Article 12 as to what shall include in the state. So, state may include everyone. That is particularly other authorities as expanded by the Supreme Court, besides Government of India, Executive, then Legislature, Parliament, and state legislatures, etc. So here you see the state shall not make. There is a clear duty or obligation on the state that state shall not make any law which takes away or abridges, the fundamental rights which are conferred by part 3rd of the Constitution. Okay, so this is one of the duty in part 1 of Article 13 clause 2. The state shall not make any law which shall take away or abridges rights of the persons which are conferred by part 3rd of the Constitution. And any law made in contravention of this clause, okay, any law which is made in contravention of this clause shall to the extent of such contravention be void. Okay, so here we see that the duty is on the state. State has to enact the law. State shall not make any law which is violative of part 3rd, which is taking away, which is abridging, which is diminishing, which is reducing, which is lessening down what? Fundamental rights. Okay, so fundamental rights cannot be taken away by making any law. This is an obligation. Second point, if state violates this provision, or if it contravenes that provision, if it makes any law which is in derogation of this fundamental right, then to the extent of contravention, the law shall be declared as void. The law shall be void. So again, like clause 1 of Article 13, it is again not automatically be declared as unconstitutional. It has to be declared by the court as unconstitutional. So in these two clauses, we have said that law is to be declared as void. Okay. Now, what shall be the law? This has a question which must come to your mind. So clause 3 of Article 13, that is divided in two parts, clause A and clause B. Clause A of Article 13.3, that is in this article, the very important word which have been used in Article 13.3 is that unless the context otherwise requires. Unless the context otherwise requires. Now, this is having a special meaning, and basically this is related to the customs and usages also. That Article 13.3 caption, that is in this article, unless the context otherwise requires, because we all know that the customs and usages are not enacted laws. They are not made by any of the state. So why we are including that in Article 13 that speaks of the law? So this, unless the context otherwise requires, that is very important. And Dr. Ambedkar, while the debate was going on, he also spoke in this term when one of the member, Nazaruddin Ahmad, when he spoke that the custom and usages should be brought in, should be seen in terms of Article 13 clause 2, then Dr. Ambedkar said that the very words unless the context otherwise requires gives the meaning to that particular term, customs and usages. And we see that Article 13 clause A says that the law includes. When we say that law includes, it's an inclusive definition. Okay, so it includes what? It includes any ordinance, orders, bylaws, rules, regulations, then notifications, and the very importantly, customs or usages which are having the force of law. which are having the force of law. Now, you see that in Article 13, Clause 1 and Article 13, Clause 3A, two terms have been used. In Article 13, Clause 1, it starts with laws in force. And Article 13, 3A speaks of force of law. So when these two terms have been used in Article 13, then it requires a meaning of laws in force as to what shall be the meaning of laws in force. When we talk about the force of law, that simply means the customs and usages which are having the force of law, which are being used for the time immemorial, which have been used by the persons of that particular habit, heritage, the person, the customs and usages which are being having a certainty, which is having a perpetuity, various essentials of the customs and usages, so that it is having the force of law. But when we talk about the law in force, then it has to be defined, it has to be explained, and simply this has been explained by Article 13(3) Clause B, when it says that law in force includes the laws passed by or made by the legislature. As I told you that custom and usage cannot be enacted by any legislature or any of the competent body, and laws can be enacted. So laws in force means that it includes the laws passed by or made by the legislature or any other competent authority or body in the territory of India before the commencement of this constitution. So we know that prior to the commencement of the constitution, we all were in the British slavery. We were having a colony of the Britain, and the laws of the Britain were also applicable to Indians. Then the Indian laws were also there. So many laws were in existence. You see, the entire criminal law is nothing but the production or manufactured by the Britishers, whether it be criminal procedure code, it be civil procedure code, evidence law, contract law, IPC, every law. So that was in existence. So that was made by the competent authority at that time, because they were competent to make the laws. And that's why when we talk about the law in force, that is only law in force included in this definition means that has been made and enacted by the legislature, which is competent to enact. A competent authority has enacted. And simply law in force does not mean that any custom or usages which were in existence, that would also be covered under the category of law in force, because that has not been enacted by any competent body. So this is the difference. And that's why you see in the Sabarimala case also, and in this this Shaira Banu case, in both these cases, you see that that term has also been discussed by the court of law, whether customs and usages under Article 13(3)(a would have the force of law or not, would be considered to be law in force or not. Okay, so here this explanation under Article 13(3) Clause B is important for the purpose of understanding law in force are only those laws which have been enacted by the competent body, by the competent legislature, competent authority in the territory of India before the commencement of the constitution. So law in force would be that, and force of law, that is having, that is of the usages as well as of the custom. So we see that this having the force of law before the commencement of the constitution, and which are not repealed also, which are previously not repealed, that must be in existence. And that's why you see Article 13 Clause 1 says laws in force which are in existence. And here in explanation you see that those are the laws that must not be repealed previously, that must not be repealed by the authority which has enacted that. So Article 13(3)(b) says about laws in force which are not previously repealed, and such are the laws which may or may not be in operation. It is also important because India was not a nation as a whole, as we are having a federal nation now after the independence. So previously there were princely states, there were various provinces also. So some law was made applicable for one province, other laws were made applicable for some other province. So it was not having the force of law at that time for the entire nation as a whole, as we are having today. So the provision which are there in the 13.3b, it is also, it speaks about that it has made it may be in existence, it is not repealed, but it is also important to understand that it may be applicable either in one part of the country or to the entire country. So all these laws would be considered to be law in force. Okay, so this is article 13.3a and b, which is important to understand as to what is the meaning of law in force in article 13 clause 1. Then as I told you that article 13 clause 4, that was not in the original constitution, and that has been inserted only after 24th amendment to the constitution, and that was in 1971. So when we talk about Article 13 clause 4, which says that nothing in this article shall apply to any amendment of this constitution, amendment which has been made in Article 368. So Article 368 speaks about the amendment to the constitution. And prior to 24th amendment, there were three cases decided by the Supreme Court, particularly with reference to this fundamental rights, amendability of the fundamental rights. So I think that I had already discussed with you the amendability of the fundamental rights, wherein Shankari Prasad case, Sajjan Singh case, and Golaknath case. These three cases were very important. And Shankari Prasad and Sajjan Singh case, the court has discussed what we are now having as a provision in the constitution, and Golaknath has entirely overruled the earlier judgment where it said that the amendment is a law. Okay, so amendment is a law, then amendment, if it is being made in the constitution, that amendment should also be not in contravention of part 3rd of the constitution as per article 13 clause 2. So this was the decision of the Supreme Court in IC Golaknath case. Now, when this was the situation after Golaknath case, then it was considered by the parliament, then we cannot make any law which is violative of fundamental right, and on the other hand, we have to also take care of those provisions which are fundamental for the governance of the nation. That is part 4th of the constitution, which speaks of the directive principles of the state policy. So because you see that all these laws, all three cases in which the right to property basically was at stake, and that was challenged, and because of that it was considered that there is a need to bring an amendment in the constitution, and article 368 as well as article 13 along with other provisions were also amended. So you see article 13 clause 4 was inserted by 24th amendment to the constitution. A similar provision is also inserted in article 368 also. It is not only that 368, this article 4, subclause 4 has been inserted here. A similar provision is also inserted in article 368, where you see that nothing in this article shall apply to the amendment of the constitution made under article 13. That 13 will have no application to amendment there. So article 368 as well as 13 had also amended by 24th amendment, and now onwards after this clause 4, you see amendment is not a law. This is clear. So these are the provisions of article 13, which is divided further or subdivided in 4 clauses, which speaks of the pre-constitutional, post-constitutional law. It speaks of the law as to what shall be included in the term law and whether amendment would be a law or not. So on these 4 terms, we have to expand further on basis of various case laws, on the basis of the doctrines which have been evolved by the Supreme Court, on the basis of the other provisions which are to be taken in relation to article 13 of the constitution. So all these things relating to the case law and the doctrines, I'll be discussing with you in the next term. Okay. So if there is any question, then you can ask on these points.